Good afternoon and a very warm welcome to the Myerson Solicitors Commercial Agency webinar, today, Tuesday, the 5th of October. My name is Suzanne Carr and I am one of the senior solicitors in the dispute resolution team at Myerson, specialising in commercial agency law. The purpose of today's webinar is to take a closer look at the issue of variation of agency contracts, an issue which I know from experience many agents have encountered during the pandemic. I'm going to start by looking briefly at the relevant legislation, the Commercial Agents Council Directive Regulations 1993. Then swiftly moving on to look at some common reasons for variation during the pandemic and some common changes principals seek to make. I will then look at how the change might be imposed, the rights of the principal to vary an agency contract, and most importantly, the rights of an agent to object. I will focus on what an agent must consider when faced with a proposed variation and some top tips. At the end of the webinar, I will touch briefly on the impact we have seen in the value of termination payments due to the pandemic, followed by a short question and answer session. The Commercial Agents Council Directive Regulations, commonly referred to as the regulations, is the legislation which applies to commercial agents selling goods in Great Britain. They can also apply where an agent is selling goods in an EU member state and English law applies to the agency contract. For the purposes of today, I will assume that the regulations apply to the agency. It is an unfortunate consequence of the pandemic that the manufacturing and retail sectors have suffered greatly, and this has had a very damaging effect on many agents' sales. However, it is fair to say that not all have been impacted so negatively, and I have certainly seen agents who have been able to take advantage of one consequence of the pandemic, which is a huge growth in growing online sales. Some agents have been able to take advantage of online accounts which before the pandemic may have been very small, minor accounts, and have now grown into their biggest and best accounts with phenomenal sales. It's in both scenarios that I've seen principals seeking to impose changes to agents' contracts. And I think it's fair to say that in most cases, the changes are beneficial to the principal and not to the agent. And most agents are keen to resist such changes wherever possible. In my experience, there are a number of common reasons given by principals for the changes they seek to impose. Typically, they are a decline in sales, resulting in the principal needing to cut costs and increase profit margins, a desire to restructure the sales team to reflect post-pandemic working practices, and a need to bring all of the sales team in line. Often, customers are taking much longer to pay invoices due to the impact of the pandemic on their businesses, and this can result in the principal wanting to impose different payment terms for the agent. And finally, the principal often has a perception that the agent is achieving too high a level of remuneration for the level of effort being put into the agency. This last reason, in my experience, is relatively common, especially where online sales have increased significantly and the principal perceives that the agent is almost getting a windfall, having not put in any additional effort towards sales. These changes can sometimes be minor, but sometimes can be very significant indeed. And it is important that have to object to the proposed change or changes. The principal's answer to these issues is often to seek to impose one or more changes to the terms of the agency. I will now briefly consider some of the more common changes which the principal might try to impose. It may involve the principal attempting to bring accounts in-house, particularly where those accounts are very large or those accounts have seen significant growth in online sales. They may seek to remove part of the agent's territory, reduce commission levels, impose more onerous reporting obligations to enable the principal to monitor the agent's activities more closely, impose new sales targets, or impose new payment terms. Having acted for numerous agents faced with proposed changes to their agencies, I am aware of how frustrating this can be, as most agents have adapted their working practices throughout the pandemic and have been doing everything possible to maintain or increase sales levels. And to be penalised for something which is completely beyond their control is extremely demoralising. And this often creates very bad feeling between the principal and the agent upon the principal seeking to impose a significant change to the agent's terms. There are different ways a principal can seek to formalise a variation, and this is likely to reflect whatever the current arrangement is in place between the agent and the principal at the time. So where an agent already has a written contract, the principal may ask the agent to sign a new contract incorporating the new terms. Where the agent does not have a written contract and the agency is simply verbal, the principal may seek to put a written contract in place. Or alternatively, the principal might simply email the agent setting out the proposed new terms, asking the agent to agree to them. The agent's legal position will be similar, whichever of these applies. So faced with a proposed variation, the question the agent always wants to be answered is, what rights does the principal have to vary the agency? And does the agent have to agree to the new terms? First and foremost, the agent needs to understand his or her legal position, i.e., are they obliged to agree to the terms under the terms of the contract? And there are two main issues to consider, and those are, what are the terms of any written contract? And also, what is the significance of the change? The agent needs to identify whether the proposed change is significant or whether, in the context of the agency, the change is minor. And the position is very different depending on which of those it is. If the proposed change is minor, the agent might not have the right to object. The agent might be obliged to accept the change in accordance with the duty of good faith, which is imposed on the agent under Regulation 3. And I should say here that it's unusual to see a duty of good faith in English law. But Regulation 3 is unusual and requires an agent to act dutifully and in good faith, and to comply with reasonable instructions given by his principal. And this does mean that the agent must assess the extent to which the proposed variation is a reasonable one. If it is concluded that the new term is minor and reasonable, then the agent will be obliged to accept the change. An example of such variation would be a request to change the agent's way of working, such as a new system of order management, or a request for reasonable reporting by the agent on customer visits. If the agent does not comply with that request, he may be in breach of Regulation 3, and that could entitle the principal to claim damages from the agent if the breach has caused the principal a direct financial loss. If the proposed change is significant, the position is very different, and the agent is within his rights to object. As a general rule, a principal can't impose a significant change without the agent's consent, unless, and importantly, the contract gives the principal the right to do so. So just considering when a contract might give the principal the right to impose a significant change to the agency. A contract which contains a term which purports to give the principal a right to vary the agency in whatever way it chooses may not give the principal the power it first appears. If it appears to give the principal an unfettered right to vary the terms of the agency, this does not allow the principal to vary the contract in whatever way it chooses. Such clause will be subject to an implied term that the principal must exercise this right properly. So there will be circumstances where the proposed variation would not be allowed. For example, if it was exercised for an improper purpose. So whilst on the face of it, the principal may believe it can impose whatever change it wants, a principal must be very careful to ensure it is exercising its rights properly under the terms of the contract. Another point to bear in mind is if the contract says that any variation must be in writing, this requirement must also be followed. If it's not, then the variation is unlikely to be effective. In many cases, the agent won't have a written contract, or the contract may say nothing about variation. And in those circumstances, the principal will have no power to impose or force a significant variation. If it does so without the agent's agreement, it will be in breach of contract. And in some circumstances, this may entitle the agent to deem the contract as at an end with immediate effect and claim a termination payment. However, this would need to be considered very carefully in the circumstances of each case. So how can an agent protect his rights when faced with a proposed change to the terms of the agency? It's important the agent gets advice quickly, particularly if the proposed change is significant, and I will come on to talk about this some more shortly. Once the agent understands his or her rights, it is important the agent raises his objections and records them clearly in writing. Raising objections verbally at a meeting or over the telephone won't be sufficient. There does need to be a record of the agent's objections to which the agent can refer back to at a later date if necessary. But is this enough? What if the principal ignores those objections and imposes the new terms regardless? In those circumstances, the agent must be very careful indeed in allowing the agency to continue on the new terms. The agent should make it very clear that in continuing with the agency, the changes are not accepted. If the agent allows the agency to continue and works under the new terms without recording that those terms are not accepted, the agent is in real danger of being found to have accepted the variation. And if the agency is subsequently terminated and the agent brings a claim under the regulations, if an agent can point to his non-acceptance of those new terms, it will be much easier for the agent to make out a claim for breach of the agency agreement. I mentioned earlier that when the principal imposes a significant change without the agent's agreement, the agent must consider the position very carefully. And that is because if the change is fundamental, if it goes to the heart of the agency agreement, it may entitle the agent to treat the agency as at an end and claim compensation. However, in some circumstances, the agent may choose to allow the agency to continue nonetheless. So the agent will need to decide fairly swiftly whether to treat the agency as at an end or whether to continue with the agency and reserve the right to claim damages. It's very important to note the agent only has a limited time in which to make this decision, and it is imperative that legal advice is obtained in this situation. If the agent terminates and had no legal grounds on which to do so, the agent will have lost his right to a termination payment, and the termination payment could be significant. If the agent says nothing about the proposed change and carries on with the agency, the agent will be deemed to have accepted the variation and is again likely to have lost any right to claim compensation. The good news is that in many cases, the agent does have the right to object to the new terms and can often negotiate with the principal to agree a way forward. However, in some circumstances, the principal will seek to impose the new terms and the agent will say those are terms which it simply cannot live with. And in those circumstances, the terms may be forced upon the agent despite the agent's protests. This will often result in the agency coming to an end, and that will be either due to the termination by the principal or the agent accepting that the agency has been brought to an end due to a fundamental breach of contract by the principal, and a claim under the regulations will then need to be pursued. It may be possible to negotiate with the principal to agree terms on which the agency will come to an end. A settlement, in my experience, is almost always preferable to litigation and should be explored by the agent if the parties cannot reach agreement as to the terms on which the agency will continue. In the final part of this webinar, I would just like to consider briefly the impact of COVID on the value of termination payments. It will come as no surprise that this is an issue which has arisen in almost every agency termination I have seen during the pandemic. The issue arises more so with compensation payments as opposed to indemnity payments. And that's because compensation looks at the value of the agency at the date of termination and takes into account recent sales income. As many agents have experienced a reduction in sales during the pandemic, this is often used by principals to argue for a lower valuation figure. For those agents where sales have, in the months prior to termination, been considerably lower, the principal will often argue that the maintainable earnings of the agency, for the purposes of calculating compensation, will be much lower. But in my experience, it remains arguable that the maintainable earnings figure, and by that I mean the earnings that a hypothetical purchaser would consider to be sustainable had the agency continued, should take into account levels of sales income before the pandemic and not just the level of income during the months leading up to termination. And if the agent's revenue before the pandemic was relatively static, and the agent can show that his or her income has only dropped due to COVID and is likely to return to pre-pandemic levels in the short to medium term, then a maintainable earnings figure, which effectively discounts the period over which there has been a drop in sales, is much more plausible. However, it is almost certain that principals will try to argue that where there has been a significant decline in sales, that the compensation valuation should be lower. It remains my view, as it has throughout the pandemic, that the courts are unlikely to penalise an agent who has suffered a drop in sales leading up to termination, where the agent can show that such a drop in sales was temporary and due to COVID. It is important to remember in every agency dispute that the underlying purpose of the regulations is to afford protection to agents. And the case law we have seen over the last decade has typically been very agent friendly. However, it still remains to be seen how the courts will value compensation in these circumstances. And I suspect it will unfortunately be some time before we have any reported cases which will provide guidance as to the approach the courts will take on valuation during the pandemic. That brings me to the question and answer session. But before I do so, I'd just like to thank everyone again for attending today. And please do get in touch if you have any questions, and the details are shown on screen. If you can just bear with me a few moments whilst I consider the questions. I can see there's quite a number of questions. Okay, forgive me. So I think the comments in the chat section aren't questions, they were just chat. So it doesn't appear that there's any questions for me to answer, but please, if you do have any questions that you would like to run past me, please do drop me a line at any point or give me a call, and be more than happy to talk those through with you. Thank you. Oh, forgive me, there is one question which I'll just have a look at. So the question is, what is a reasonable amount of reporting? Is it daily or weekly reporting? My view on that would be daily reporting would be quite an onerous reporting obligation. I would typically expect to see weekly reporting or possibly monthly reporting. I think if the agent hasn't been required to report to the principal at all and a daily reporting obligation was imposed, that could certainly be seen as a significant change. I think it depends on whether the agent is already obliged to report and what the frequency of the current obligation is. There's also a question, have agents' rights changed since Brexit? The simple answer to that one is the answer is no. The commercial agents regulations are incorporated as what is known as retained EU law, and they continue to be enforceable. So for commercial agents who are operating in Great Britain and who are covered by the regulations, there is no change to their rights. it does remain to be seen whether Parliament will change the legislation in future. Now we're no longer part of Europe, but there's no suggestion that that will happen at the moment. And I think if it does, it's definitely not going to be on the list of priorities, and we're unlikely to see any change in the near future. There aren't any more questions, so that brings me to the end. Oh, there is one more question. Apologies. The question is, what would a typical compensation calculation be? If I can, I could probably spend a good 10 minutes answering that question. I can simplify the answer. The answer is, you first of all have to identify what the maintainable earnings of the agency are at the date of termination. You have to consider the running expenses, the operative expenses of the agent in relation to that particular agency. And then you have to consider what a hypothetical purchaser would have to pay somebody to effectively perform the role of the agency. Those are all things which are taken into account in the calculation. And then ultimately a multiplier is applied, which takes into account the risk factors relating to that particular agency. So it's very much bespoke to the agency in question. And it is ultimately a matter for expert accountancy evidence. But as specialists in commercial agency law, we can and we do regularly provide clients with estimates of the valuation of Regulation 17 claims, whether those are compensation or indemnity entitlements. There's one more question, which what compensation would an agent be entitled to if he was to retire after reaching pension age? So the regulations provide that an agent is entitled to Regulation 17 termination payment upon reaching a reasonable retirement age. So provided the agent can show that he has reached a reasonable retirement age, then that right will automatically apply, and the agent can bring the agency to an end and claim the compensation or the indemnity, depending on which of those he is entitled to, and that would be calculated in exactly the same way as any other Regulation 17 termination payment. One more question, which is my principal has taken on business that are house accounts and has extended his delivery times significantly. I'm not absolutely sure there whether the question is saying that the principal has taken away accounts that the agent had and has taken them in-house. If that is the case, then that may well amount to a significant change, which would be a fundamental breach of the agency contract. If delivery times have been extended, that isn't really a change to the agency contract. That's just a change really to the principal's business, and that is, in my view, unlikely to amount to a significant change. There's various other questions, just bear with me 1 second. We've got a question, what would a significant change be? Any change which changes the level of remuneration or the structure of an agent's remuneration would almost certainly be a significant change. Equally, reducing the agent's territory or taking accounts and bringing them in-house, if those are significant accounts, would likely be a significant change. And finally, as a result of the enforcement, what would you consider a minimum worthwhile claim value? I think the answer to that is every claim has to be assessed on its own facts, and the strategy that's pursued will to some extent depend on the value of the claim. So with a small value claim, for example, if the claim was we'll say £50,000, it may be that the strategy is to seek to negotiate a settlement with the principal, and not an intention to issue proceedings. But it does very much depend on not just the value of the claim, but also the merits of the claim. But legal costs are expensive, litigation is expensive, and when you're considering strategy with any agency dispute, or indeed any dispute, the proportionality of the cost does have to be considered. I think I can finally say that brings me to the end of the questions. So thank you for bearing with me, and I hope everyone has a lovely afternoon. Thank you.